Good evening, everyone. Welcome to another Wednesday webinar with the Property Law Alliance. Welcome, Solna and Bruno.
Hi,
Hi,
Marilee.
Marilee.
How are you guys doing? Keeping warm, hopefully.
That's
I
why
do-
I'm wearing this today. Forget the suit, forget the shirt. I need to keep warm.
Bruno, I was actually thinking about you this morning. I was putting, like, I have my gas heater next to me. I have a humidifier behind me. I was sitting in a blanket, and then at some stage, I'll admit this, I got up and I put my robe on as well, like my like my nightgown. I was like, I put that on and I got back behind my computer. I was working on a legal opinion and I was typing and I'm like, my fingers are frozen. And I thought, this is your fault, Bruno. Last week, Wednesday, you said, and it is going to get worse. And you were right. But
I
thank
didn't
you
so much
for your
pause it. I
attempted
didn't so much
warning.
pause it. Yeah.
But thanks for the attempted warning. But this morning, while I was working with like a million heaters and like a nightgown and everything, I was like, thanks, Bruno, you tried.
It actually helps to get up a little earlier, switch all the heaters on, and then if you need to get back into bed, do it, and then come back in about an hour when the room's already warm.
Ah, that's the answer. Well, I take a, a cold shower every morning for happy nervous system purposes. And I must say the last 3 days, my usual cold morning shower was a little, definitely more intense cold therapy than, than the other days. I knew about
Like
it.
almost death. Yeah.
Exactly, which is why I'm still drinking tea. I'm just trying to warm up from my shower this morning.
All right. Okay, and then I just firstly want to ask, is there anything new with the legal process with case lines and municipal reports that you've made any progress on that hasn't been more delayed during this time? Is there anything new from your side? I know Solna or Bruno. Sorry.
So from my side, it looks like things are still functioning. Case lines has been a bit slow. There's been a couple of complaints I've seen by a number of attorneys regarding the acquisition of dates on case lines across the board, not only evictions. If you are lucky enough to get an answer, that's great. You have a date, you can proceed as per normal. So there we haven't experienced anything different to what we were experiencing in the past. One of the issues that I did encounter was, and just to give kind of the context to our viewers, when we're doing an eviction, one of the requirements is that the municipality be involved. And the reason for this is to avoid homelessness and to kind of entrench or promote the right to adequate housing. The legislator felt that the municipality has to be involved in evictions and give comments as to alternative accommodation or whatever the case might be. And in order, by the way that they do this is by filing a report. And this report normally accompanies our bundles when it goes to court so that the judge or magistrate has an opportunity to read it before granting an order. What we are experiencing now is that the municipalities aren't drafting these reports, or at least if they are, not all of them are uniformly doing so. So we had an issue where a judge commented that he didn't want to grant an order without this report, especially if there's averments being made as to homelessness. And when we contacted our people or our colleagues at these firms that do it and at the municipality, it seemed to be that they're, as a rule, not doing the reports right now. They're holding off. So these assessments that the municipality normally do aren't being attended to. And that's, yeah, but that shouldn't affect many evictions. Some evictions you can get away without it, but the harder ones, it might cause a bit of an issue.
No, it's we have the same situation on the municipal reports, Bruno. But I must say, unfortunately, the case lines are definitely giving us a bit of a run for our money. And you said the same thing. We had a matter in court this morning, and one of our associates, Claire, she was the one running the matter, got in on the motion court. What happened is the registrar issued the actual link for the Teams meeting, so for the actual court hearing, under the wrong case lines item. So about 70% of the matters that should have been enrolled for today's motion court wasn't correctly enrolled. So the judge didn't have those case line matters in front of him. So all those matters were removed from the roll, because obviously the judge can't suddenly just enroll 70% of his roll without anything in front of him. So all those matters were removed. Unfortunately, our matter was one of the ones that had to be removed, simply because the registrar didn't link the hearing to the right case lines link, which I must say, things like that, I don't know if you're experiencing the same frustration, but I mean, if you tell this story to your client, your client's like, what? Could you find better excuses? And I'm thinking, dude, it's as weird for me and it's as bizarre for us as attorneys as it is for our clients. Do you have a similar thing, or are we doing it wrong?
Oh, no. So last week I had a sequestration on the roll. When we looked on the roll, it wasn't on the roll anymore. We had been given the date. We had confirmed it with the right email addresses. And then coming up to the date of hearing, we start looking for it on the roll, not there. Our counsel managed, I suggested our counsel try and hijack one of the Zoom links and try and enroll the matter. The judges don't seem very, very willing. So yeah, we just had to go get a new date. And the problem with that is we did everything exactly the way that they said. So we got the provisional date, we emailed it to the final enrollment, and we waited. And unfortunately, if it wasn't taken from the final enrollment to the roll, that's it. You just need to do it again.
But I must say, it's pretty sad to be in this position where you can't tell your client. Usually you can tell your client, listen, this is the date, we're going to go to court, you'll make it happen. But these days it's like, even if you have a court date, you're like, okay, we're going to hope that the registrar sends you the right link. And then, so it's a bit of a matter of faith at this stage to be an attorney. Honestly, I don't think being a lawyer right now is the easiest thing, because as much as we experience those frustrations, so our clients are as empathetic as we are definitely sharing those frustrations with our clients.
Yeah, absolutely. And I suppose the biggest issue is the uncertainty where one client, so for example, I'm looking at an email I got this morning from that JHB provisional email address, affording me dates from the 17th of August to the 23rd of September, right? And it's like, wow, it's a date in 1 month's time. That's incredible. So I can put my section 4.2 down. We asked them for 2 dates. I can select the date for the final hearing. But this is one matter out of all the matters. So this one client just happened to get lucky that his email got answered, and now we jump on this. And that's if he's lucky enough for the matter to actually be enrolled. So whatever date we pick, the problem as well, with evictions is we need a section 4.2 date. If we come right and we get it, we need that final hearing date as well. If we don't come right with the section 4.2 date, we can't do anything on the final hearing date. So it's a bit of a balancing act trying to get it right. Like everything needs to go perfect, or you almost need to start again or come up and start making plans.
It's exactly that. And especially with your 4.2, if you lucky and you get it on the date that you should get it, and the sheriff doesn't want to serve, then you need to factor in that delay from the sheriff to get to your eviction hearing. So I think that the message is, guys, we understand and we share your frustration, but please be patient with us. We are seriously all doing our best, but most of these things are, unfortunately, we're reliant on third parties who sometimes make their own rules, which makes it a little tricky for us.
Yeah, and I mean, I suppose our clients need to understand this. The system, especially with case lines, wasn't intended to be launched just yet. So it's a premature system trying to carry the burden of a full-out legal system. So they also need to understand that, yeah, we can criticize the judiciary or the relevant department, but even by our own standards, if the system wasn't ready and now we're putting pressure on it, what do you think is going to happen? Yeah, so I suppose we also need to be empathetic towards that.
Yes. If 2020 is going to teach us one thing, guys, it's going to be empathy.
Absolutely.
Definitely. All right, thank you. And then I want to get started on the questions we received. We received quite a few. All right, so I'm going to start with one for you, Silna. Hi, Silna. Do you need an outgoing tenant's consent for quotes of things to be done that was not done, like repaint of few walls and cleaning of light covers and sealing around lights?
Yes, so thank you for directing a question at me that I actually know the answer. I was so nervous when I saw that ISIL now. I'm like, whoa, please ask me something that I don't need to throw to Bruno. Yes, so thanks for saving me there. So the answer is 100% in terms of the Rental Housing Act. Those things that the tenant is responsible to clean or to fix or whatever the situation is in the property in terms of the lease agreement or in terms of the regulations to the Rental Housing Act. The Rental Housing Act only requires the landlord to provide the tenant with invoices and or receipts of the monies that was deducted from the deposit. So the tenant doesn't have the right to consent to the specific repairs, especially not to the cost of the repairs. This is up to the landlord, because remember, it's the landlord's property. So the landlord is entitled to use the kind of paint, the quality contractor, those kind of things, because it's his property. The tenant will obviously want to go for the cheapest options, where it's the landlord's property and he has to cater for paint that has to last for, say, 5 years, indoor paint, 7 years outside, things like that. So the tenant doesn't have the right to say, to choose a quote at all. There's this thing that I've heard a few people mention, that the landlord has to provide the tenant with 3 quotes and then the tenant can pick. That is not a thing. So it's very important to know, no, it's the landlord's prerogative to choose the repairs, but the Act requires the landlord to provide the tenant with the receipts so you can show that you've actually deducted the correct amount. However, Marilee, before we started, Bruno, you threw something cool into the mix, which I think could be valuable on that question. So I think let's maybe add that to the conversation.
Yeah, absolutely. So, so interestingly enough, so I agree with you completely on that. So there's no dispute there. The landlord has the right to choose the best product or the best service in order to best take care of his property. There have been situations, however, and I can imagine these. So if you exaggerate that question, you go, well, what if the landlord is doing it himself, like you mentioned, and he's invoicing now for his labor and materials, and he's overcharging, inflating the prices? Or, for example, the landlord decides to go above and beyond, and instead of restoring the property to the condition that it should have been, he tries to actually improve it and wants the tenant to kind of carry that excess cost. And that's actually a very interesting concept, because in those instances, so obviously my advice would have been that my advice would be that in those instances, the tenant can dispute those invoices as being excessive. Have you ever experienced a situation like that?
I have, and usually what I do is that, to be quite honest, I usually don't think it's worth litigating on per se.
Oh, yeah.
Usually I advise the parties to approach the Rental Housing Tribunal more for a mediation type situation, and then mediate the situation and move along, because I have seen landlords inflating the cost, or like you rightly say, the tap was broken, the washer in the tap was broken. Now suddenly the tenant gets this invoice for installation of T-volley taps and amazing new tiles, and it's like a 25,000 Rand bathroom redo instead of one washer. So if that happens, my recommendation is always the tribunal and not really court.
Yeah, absolutely.
Okay, perfect. Thank you so much. All right, then on to the next question. Nondwe says, okay, I need guidance and help, please. There's a deceased estate property that I'm interested to buy, but the house has a land availability agreement endorsement on it. In fact, all the properties in that street have this endorsement. What does this endorsement mean, firstly? And then the second part of the question is, when I check the property report from the deeds office, it says the original or first owner of the property was Transnet Limited, and then the company sold the house in 1999. The house was never extended or renovated. It still maintains its original state. My plan, however, is to further develop it and build flats for rental. Now, I'm not sure if this endorsement does not restrict further development of the property. I'd greatly appreciate some help. Right, Bruno, do you maybe want to get started on that?
So I'm not an expert. I'm not an expert necessarily on land availability agreements. I've encountered it like very, very few times. So what I do know about land availability agreements is where you try to get an intermediary involved, where you don't want to sell the property to that person and then he develops it. So you want to make the property available to that person for the sake of development. So this is done especially for housing schemes, low income housing schemes, specifically to give homes to people. So for example, you'd find that state-owned land would be made available to a developer who would promise to develop the land in a certain way. So that agreement would be between the parties, and transfer of ownership would only take place generally to the end user. So it would just be an agreement where development would be allowed, and the end user, after the development takes place, is allowed to actually take transfer of the property. We have seen situations where transfer is never effected or the development's never effected. So ultimately, the original owner stays owner of the property. But I mean, to answer the question, for the most part, the terms of the agreement would have to be considered. If she does want to develop, is the purpose of the land development agreement to provide housing and ultimate transfer to persons? Because if that's the case, she wouldn't necessarily be able to develop and then hope to rent it out. So she wouldn't be able to keep the property as a buy-to-let. In that instance, you'd probably have to sell the property on to the end user and make a profit from there. So there are ways of using this as a developer, but that agreement is paramount. You'd need to do a proper assessment.
Okay, all right. So it's going to be different from agreement to agreement. All right, thank you. And then the next question. Hi, I have land at Mpumalanga, not my state land. They have coal. I want to apply for small-scale mining. Solna, do you want to maybe get started on this one? I don't know if anyone had experience in this field.
I'll happily take him after Bruno took the previous one. I think you saw me raising an eyebrow to the level where you knew you're not even going to ask me if I agree. Like, it's perfect.
Well, you've got this one, so don't worry. Yeah.
At least we're taking turns, Bruno. Between the two of us, we
The
tend to
answer's
have
always
the answer.
there. Yeah.
Some way. So luckily, Marili, I have some experience in this, actually more from a personal matter. My parents have a farm in Mpumalanga. So when it comes to coal and mining rights and things, luckily I have some personal experience in that. So the thing that's very important to know is that mining rights does not accompany the right of ownership. So what I'm saying is, if you buy the land and you're the owner of the land and there's coal on the land, it's not yours. Yeah, anything under the surface of land doesn't belong to you, it belongs to government. And only government, and I'm so sorry if I'm breaking the viewers' heart on this one, because very often people specifically buy land, especially in Mpumalanga, for coal and for mining purposes, only to then discover on a random Wednesday evening that the coal does not belong to you. So the coal belongs to government, and you need to approach Department of, who's the mining department people? The mineral Department of Mineral Works and something or the other. I should have just stopped at Mineral Works, but there's definitely Mineral Works in the name. So the Department of Mineral Works, they are the department to approach to obtain this certificate and the right to mine. Only problem is it takes a very, very, very long time. I've personally been through the process with the land I just mentioned, and it takes a very long time, and very often the rights are already sold to a third party, and the holder of the right, of the mining rights, does have a pretty long time. I think it's really in the region of 2 to 3 years, which they have to commence their mining, and only if that lapses can they sell it to another party. Well, can they grant the rights to another party? So there is definitely a tender sort of process, and then an application process. But when the rights are already awarded to a third party, you will have to wait for that time period to lapse before you can apply for it. And the joy about all of this is, unfortunately, accompanied in the right to mine, you can also then extend that right. So even if you have this long time period to mine, if you don't get around to it, like the day before, it's almost like the national state of disaster. And like just before the time you can apply for an extension, and it will be extended. So unfortunately, my advice will be, don't go to any attorney. Like I'm not an expert in this at all. Bruno, you mentioned, not you. There are specific firms that specialize in mining and mining rights. That's the firms you need to be with. I can't recommend a specific firm. I've never worked with a specific firm on mining rights, but it's important to get to the right lawyers. Similar to an eviction, you don't really want a GP doing open heart surgery.
So we've worked, just if the viewers are interested, we worked with Milan Skulls on the mining side. One of the directors is actually a relatively good friend of mine. So, and I've always had confidence in his abilities. So when it comes to mining, I just pass it off to him.
Brilliant. So maybe what we can do for that particular viewer is just send a private message with your contact details, which will then pass on to Bruno. And Bruno, you can, if you're willing, just share his contact details.
Yeah, absolutely. Yeah.
Brilliant.
Yeah, thank you. That will be great. All right. And then the next question, it's a bit long, but let me read it for you. All right. Good day, all. Kindly advise. I have a property that I bought in auction on 2016 in Thokozo, Gauteng. I still can't access it due to unlawful occupants who don't want to vacate the property. We have done the sheriff eviction, and as soon as the sheriff and the police leaves, he moved back in with the help of the community. I opened a case of trespassing and he was sentenced, but he's still outside, and next court date is 18th of July. I've lost so much money in this case, and I tried a few estate agents to sell this house for me, but as soon as they hear there is community involved, they withdraw. The only thing I have is the original title deed and municipality bills for this house. Even the municipality account is in my name. Other advices I got is to get people to move into the house by force, but no guarantee of what will happen if they do that, and I just don't want to break the law. The law is failing me, as this guy was supposed to be arrested already, as he was found guilty already, but he is still in my house and the law is not doing anything about it. Some other people who are interested in buying the house want inside pictures of the house, of which I don't have, as I don't have access, and really this is frustrating. I really don't know what else to do or where to seek help, as I've done everything in my power and I keep losing money. All right, so that is a mouthful. I don't know if you have had any experience with similar matters. Maybe Silna, I know you mentioned previously that you had a similar matter like this.
Bruno, I don't know about you, but I have goosebumps because I hate hearing these things. And unfortunately, Marily, yes, the matter you're referring to, is a matter I still have pending in Orlando. I will actually just look for it. I did a story on this with carte blanche, and this was in November 2018 already. It was so bad by that time that carte blanche did a story on this matter. And to this very day, guys, those people are still in the property. I've done 4 evictions executed with the red ants, with private security, armed security companies. Those people are still in that property. And also trespassing cases, matter pending. I've personally testified in the trespassing cases, really did everything we can, but every time we execute the eviction, within, like, the moment the police leaves with the sheriff, you start hearing the whistles blowing. And as soon as you hear those whistles, then you know it's dansies. The community rocks up and they simply move the items back into the property. Fair enough, you can obviously sell the items for in execution, but even without that, it's to move somebody into a property like that after you've successfully secured the premises, the moment, and I've been successful twice on this eviction to really keep the community at bay with security guards in the property, and on 2 occasions I had to withdraw the security guards from the property because their lives were in danger. Bruno, I wish this wasn't such a regular thing, that we sit with our hands in our hair and just say, I wish I had an answer for you. So that's a pretty dark answer, but Bruno, maybe you can make it sound a bit more pleasant than my bleakness right now.
Thank you. Yes.
I do what I can. It's to get back at you for making it cold.
So I've had similar experiences. Mine specifically was in Shoshanguve. One of the blocks there, it's very, very difficult to do evictions. In this particular instance, what actually happened is they didn't even wait for the sheriff to finish. There were so many people that as the sheriff moved the things out, they went into the trucks, because I'd arranged there to be trucks. They went into the truck, started removing things and basically carrying it back into the property. At a stage, I got a phone call with the sheriff just standing there going, well, yeah, sorry, I'm watching the things being moved back right in front of me. There's nothing that I can do. Sorry about that. So the experiences are there. And again, it's not a nice answer because everyone's looking for solutions. And 99% of the time, we come up with some sort of solution, or at least a way of determining a solution. What I can say, maybe not a silver lining, but as a kind of a consolation to our own ego for not being able to find a solution, is, so first of all, it's rare enough for it not to be something that most property investors will experience in their life. So that's the one thing that needs to be considered. So you're maybe looking at 1 to 5% chance, and it also depends on areas. Certain areas, this will never, ever happen. Other areas, it will happen. And I suppose hindsight is great. And what I'm about to say next is not going to help this client at all. But what I tend to tell with all novice property investors is, when you're looking at areas, don't just look at needs. Don't just value what you can get it for, what the market value is, what your rental would be. The one extra little bit of calculation you're going to need to throw in there is, will you actually be able to execute an eviction? And there's a level to this. Hard evictions aren't necessarily bad to deal with. I've dealt with plenty of hard evictions where the profits were there. So it's not to say, oh, there's a difficult tenant, let me not buy it. No, you can buy it. But what you're looking for specifically is, there's certain areas that are so community driven that you can see as soon as something happens, the entire community gets together. And as soon as you see that, be very careful, because those are the evictions that are going to be slightly harder. The only solution I might have for the viewer is, start interacting with the community, because if you are in an environment where you're getting resistance from them, I found in some instances that the community might actually pull together to buy the property back for this occupier or previous owner, and you might be able to just let it go, like maybe break even if you're lucky, and just walk away from this and do something else. So community leaders are big, because community leaders might listen if you show them the necessary respect. Just make sure that you have yourself a contact in the community to be able to open the dialogue, and then go in there and try come up with a plan. And if you're lucky and you involve them, you may actually come right. But again, it's a chance. There's no, yeah, as far as I'm concerned, the sheriff's done his job. There's no legal recourse. Yeah, it's basically when people have taken the law into their own hands, and there's nothing that the law can do about it.
Bruno, what's interesting about this, Marilee, I just want to check in this question, did the person specifically mention it was bought from a deceased estate?
And they bought in auction. So
auction,
yeah.
exactly. So what I think is important, Bruno, and correct me if your experience is different, but in my experience in communities like that, you usually don't have that kind of problems with a tenant that rented the property and stopped paying, and this is the legal process. The issues come in on auction sales, sale in executions, estate sales. For instance, my Orlando eviction, property was bought from a deceased estate. The deceased wife was the executor of the estate, and she had the authority to sell the property, which she did. And all of that was done 100% legally, above board. But the person that we're struggling now still to evict to this day is the niece of this particular deceased wife, so the niece of the executor. The executor had the conversation with the people in the property and said, listen, I'm going to sell. They were like, yes, sure, aunt, go wild, sell the property. And then when transfer occurred, they refused to vacate. And this is what we see time and time again. So on your insolvency sales, your selling executions, estate sales, find out before you buy the property what is happening behind the transaction. If it's a deceased estate, that we've had this conversation in one of the other Wednesday webinars as well, where our advice was also find out what the will says. If it's an interstate will, so that, if it's an interstate estate, meaning there isn't a will, find out what the relationship is between the family members and the executor. Because the next moment there's family members popping out of the woodwork. You haven't even seen them at a wedding for years. You didn't know this was your cousin. And suddenly they are laying claim to the property. And those are the evictions that seriously can take years and years and years. It's not really the eviction portion that takes that long, but it's the underlying right of occupation that is currently in dispute, the right of ownership that could be in dispute. For instance, a sale in an insolvency sale. If the validity of the insolvency or the validity of the sale in execution suddenly falls in dispute, you, as the purchaser of the property, isn't party to that fight. So you can't drive that litigation. And us on your behalf can't, because we're not a party to those proceedings. So you have to sit on the side waiting for another court to make a ruling. And those are the kind of matters that take the route of appeal in the court, which handed the order down, then the Supreme Court of Appeal in Bloemfontein, and then back again to the Constitutional Court. Those are the matters that take years and years and years. So I don't think we mean to scare anybody, Bruno, but I think it's something very important for people to be aware of, because these are the evictions that take very long. And if somebody grew up in a community I'm coming back. If somebody grew up in a community, for instance, this matter in Orlando, the person I'm trying to evict there grew up in that community, grew up in that house. So the community sees that property as that person's property. And that is the reason why the community stand up like that. If it's a tenant, they don't know the guy. They're like, whatever, you haven't paid your rent, go. But if it is somebody that was raised in a community or that's been there for a very long time, make sure the community supports the sale before you purchase the property. That is, for an investor, I think the best tip, to engage with the community leaders before you sign an offer to purchase, and not try and do that afterwards. It's extra homework, but it's going to be worth your money 1,000 times over to spend that extra time, money, and energy before the time, rather than being caught in a bit of a surprise situation afterwards.
So as you know, I do a lot of sale and execution evictions. So just to kind of confer exactly what you were saying, the connection to that being a home far surpasses any realization of legal rights, fairness, obligations, duties, whatever the case is. So that's the first thing with sales and execution is it's a home. It's something personal. It's the same concept as with the divorce where you're fighting over custody of the kids. It doesn't matter whether one of the parents actually realizes that maybe the other parent should have more rights. This is a fight. And because it's a fight, people don't necessarily think rationally. And it is the same with sales and execution. So generally, when you speak to the previous owner and you're trying to rationalize with them, it's not always that easy, and it's understandable. It's very emotional. With the deceased estates, very similar. When they're fighting over wills, and sometimes there's a second wife or third wife with a kid, and she feels aggrieved that the other wife got a house. Exactly the same thing happens, and it's not about what happened with the will. It's a fight. It's an emotional fight that you as a property investor are now stuck in the middle of. So exactly what Solna said, sales and execution, try figure out what the gripe is. So you can easily figure this out. If this person's fighting the bank and they hate the bank, go knock on the door, figure out what the gripe is. Try figure out as well from the community exactly what was said, how they kind of feel about that type of situation. Phone the sheriff up. Ask the sheriff, listen, have you experienced this in this community? Most of the sheriffs do evictions, so you can easily ask. Where with my Shoshanguve eviction, it was exactly that. The sheriff said, sorry, this particular block, I can't do it. I'll try, but I'm not going to come right. So, try your best. With deceased estates, the suggestion, aside from also looking at the will, try contract or read your contract properly. Some deceased estates and executors try and put the obligation to do an eviction on the person buying it. Same with insolvent estates, right? They say it's your problem. You'll get vacant occupation, but if it's not vacant, sorry, right? You can contract out of that. Sales and execution, you can't, right? Because that's not the nature of a sale and execution. There you take all risk. But with insolvent estates, you can negotiate that vacant occupation be part and parcel, and leading up to transfer, you can see where it's going with this vacant occupation. And if you see that it's not coming right, you've at least got the opportunity to stop. And even if transfer does go ahead, you can still go back to the seller and try force the seller to do an eviction. Try attach the purchase price until the eviction's done. Whatever the case is, you might still have recourse as long as you contract. So don't just go sign documents without paying attention to the occupation clause.
Yeah, I think that's very important advice. I think that's pretty much, if you've got that, then you're going to be pretty cool.
Yeah, no, absolutely.
Perfect. All right, thank you. And then we have a question in our comments to this video. He says, I've seen a huge gap in the property market. Do you know of any investors around KZN? No, this is not the legal side of it. I don't. I asked them to ask questions. So if there's an insight on your side.
Bruno, I suppose Sappen is the best route. So Sappen being the South African Property Investors Network. Marilee, if you can maybe just tag them in the comment, then he can maybe just join SAPN, because I don't know about specific investors, but SAPN is all you have is investors there.
All right.
So SAPN does have what's called SAPN Connect. So you can find this. You can Google SAPN Connect, and there's specifically a little tab there for deals. And if you go into deals, it'll send you an email with certain forms to fill in. Fill out those forms. It goes back into a database, and then they try link you with deals or investors in certain areas.
I promise we're not getting like anything from SAPN. We just both know of SAPN and work quite closely with SAPN and their members. So
look, full disclosure. Full disclosure, I am involved in the brokering side of things. So I do have. Yeah, so I have to,
sorry.
She mentioned it, not me. So.
Right. Then we got a question from Happy. He says, I have an agreement with an agency on the leasing of my property to a tenant. For the past 2 months, he did not pay rental and municipality utilities. They are currently on a month-to-month rental. The agent said they cannot cancel or send him eviction notice during level 3. What, or if I have any legal recourse? If we can just maybe clarify that again during lockdown level 3, what is possible? Can the process get started?
I think I did it the last time. So you're more than welcome to.
Okay, let's explain why we are laughing. There is this major misunderstanding, guys. Regulation 36, the heading says prohibition of evictions, but the content says evictions may be granted in terms of Payant Esta. And if you look back at the previous regulations, the regulations only prohibits other evictions when it is from land that somebody owns or belonging to them. So commercial evictions has been allowed all along. There hasn't been any prohibition on commercial, retail, industrial evictions. On residential evictions, there was a full prohibition of that during lockdown, full lockdown, and then that was level 5, and then level 4. Now I'm lying. In level 4, we could obtain the orders. I can't remember. That's a past us thing. Lockdown level 3, we are allowed to bring eviction applications and obtain the orders in lockdown level 3 for all residential evictions in terms of Payant Esta. The evictions that we typically talk about here is evictions in terms of PI, the Prevention of Illegal Evictions Act. And the execution of those orders, so sending the sheriff to physically remove the people, are stayed until the end of lockdown level 3, unless the court orders that you can execute. So even some cases, you can even execute, but an estate agent that's telling you that you can't do an eviction, tell him to please join the Property Law Alliance and watch our Wednesday webinars, because we're going to teach them so many amazing things. You can send them a link to this and to that estate agent. I'm glad we helped.
All right.
Was that medium diplomatic, Bruno? I think we're so over this message in the industry that people believe we can't do evictions, and why we are a little over it is simply because the impact on the industry is severe. It's really profound, because there are tenants and groups telling tenants that they don't have to pay rent because they can't be evicted, and that's simply not the truth. We do doing evictions every day, and so are you, and so is Greg. So there's really no reason to not commence with eviction proceedings.
No, agreed.
So you're just like, whatever she said.
I'll take it next week, don't worry.
You will definitely have one next week.
We can make it into a song that's, have a nice little rhyme to it.
Jingle. But
Yeah,
we
exactly,
need
yeah.
a jingle when we start this show. Eviction. I shouldn't sing, but
All right, thank you guys, and thank you for clarifying that once again. All right, I think that is about the time that we have for this evening. I don't know if you have anything else to add. Yeah, we got through all our questions, so that's a good thing.
No, I'm
All
good.
right.
I'm good.
Okay, thank you everyone for joining us, and thank you Solna and Bruno
Cool. Thanks for
for
having
all
me.
your advice. All right, and then everyone, we'll see you next week, and keep warm and safe during this time.
thank
All right.
you.
Okay,
Bye-bye.
bye.